Phil, the first one I want to talk about today is there was a case in 2022 called Thryv, and that's a company, Thryv Inc, Thryv. And under Thryv, the board expanded the legal concept of what are called make-whole remedies under the National Labor Relations Act for employees who are victims of an employer's unfair labor practice charges. Previously, prior to Thryv, those remedies were typically limited only to back pay and reinstatement. Under that Thryv decision, the board expanded relief that it ordered employers to pay when they violated the National Labor Relations Act. And those wider range of damages, but beyond the lost back pay and benefits and then reinstatement, included medical costs, credit and debt expense, job search expenses, moving expenses, and potentially tax consequences. And this marked a big change for the NLRB on the relief that they could issue against employers. There were some subsequent legal developments. In May 2024, the Fifth Circuit Court of Appeals partially vacated the NLRB's order in that Thryv case. However, the court did not outright reject the NLRB's expanded view of those remedies. There has developed a circuit court split. Not surprisingly, the Ninth Circuit ruled that the broader Thryv remedies are within the NLRB's authority. And so now there's a split in the circuits. The Third Circuit, like the Fifth Circuit, ruled that the board have limited power to impose certain types of consequential damages. Well, just in the last couple of days here, the NLRB, the Ninth Circuit Court of Appeals, reviewed another one of these Thryv cases, and it was a split panel decision from the Ninth Circuit Court of Appeals. And the Ninth Circuit Court of Appeals held that the NLRB is allowed to make employers pay for financial hits that workers take as a result of an employer's unfair labor practices, because doing so makes the employee whole under the National Labor Relations Act. And so the reason why I'm sharing this with people is that it used to be, prior to Thryv, that the employer's monetary exposure was very, very limited.
Yeah, just relatively back pay. Now there's a lot of other consequential pay associated to that.
That's right. And the reason I'm sharing this with everyone is to put it on people's radar that I think this one's heading to the U.S. Supreme Court for eventual determination, given the split in the circuit. So keep your eyes on that one.
Facing complex employment law challenges? As an AIM member, you get direct access to Ogletree Deakins' top attorneys for expert guidance and defense. Call AIM at 800-948-5700 or visit aimea.org to engage expert workplace specialists today.